Our nation's historic devotion to the due process of law, enshrined in our Constitution and upheld in countless decisions, is a cornerstone of civilized democracy. That no warrant shall issue without probable cause, that none shall be presumed guilty, that the state must prove criminal acts beyond all reasonable doubt, that life, liberty, and the pursuit of happiness are unalienable rights bestowed upon all humanity. These are the ideals that continue to serve as beacons for the better angels of our nature, except when they're not. This proposed rule guts the asylum system in an unprecedented manner, effectively illegalizing it. In tort law, there's a concept of res ipsa loquitur, the thing speaks for itself, and the naked xenophobia embedded in this rule speaks for itself. Let me be clear, it does not represent the will of the American people. I am a practicing attorney, a member in good standing of the bars of Maryland and Virginia, and a host of federal courts. For the past 18 years, I've devoted my practice to matters of U.S. naturalization, which of course includes immigration, and have proudly represented asylum seekers from Mongolia to Mexico, El Salvador to Egypt, and Ivory Coast to India. I have spent time on both sides of our southern border, advising asylum seekers both before and after they enter the United States. And as this proposed rule implicitly concedes, asylum is part of the bedrock of American jurisprudence. Effectively illegalizing asylum itself, therefore, is an end run around Congress. That our immigration system is susceptible to such manipulation is a separate problem, of course, but for purposes here, the original sin in this proposal is in the coy word streamlined. It means nothing more than a gutting of due process, robbing deserving asylum seekers the chance to even tell their story. Asylum is invariably seen as a problem, but this is only true when asylum seekers are crippled by Byzantine laws that impose impossible burdens, ease of denial, and relentlessly attack their credibility, the ability to work, live, and prosper. They cripple the bird's wing and then condemn it for not flying as fast as they, said Malcolm X. The credible fear interview process has already been gutted. The various bans and other efforts by this administration, such as the Migrant Protection Protocols, or MPP, operate to collectively pretermit an asylum seeker's application. The lucky few who make it through these highly effective walls face an increasingly reprogrammed system in which attorney generals have taken it upon themselves to certify Board of Immigration Appeals cases to themselves for the sole purpose of gutting due process protections for asylum seekers. Now the administration seeks to take it a step further and creates a true due process vacuum at our nation's border. Not a single policy of this administration has empowered or protected due process for asylum seekers. Not one. Res ipsa loquitur. I am very concerned that the real impetus for this proposed rule comes from the so-called Tanton Network. Groups like the Federation for American Immigration Reform, the Center for Immigration Studies, the Immigration Reform Law Institute, and Numbers USA have worked on the Hill for over 40 years, streamlining asylum proceedings. This term can be found in their writings dating back to the 1990s. These groups were founded by Dr. John Tanton, an avowed white nationalist and eugenicist, whose unsealed papers I am seeking to unseal from their archive at the University of Michigan. Having spent the better part of 4 years reading his writings and those of the groups he founded, it behooves our government to affirmatively disavow the counsel of the Tanton Network. Our immigration policy must be freed of the stain of white nationalism, however well it may try to camouflage itself in terms like streamlined. Seeking asylum cannot be read separately from the right to life, liberty, and the pursuit of happiness. All of these rights are unalienable, and we do not streamline unalienable rights in the United States of America.